I think it's gonna be okay. Yes. Okay, so I can start my lesson on. But before my lecture, I would like to um, make some precisions about the next week examination, midterm examination. It will be very easy. It will be about the concept of state in international law. As you remember, I explained basic notions, basic elements of the definition, which are the territory, the population, and an organized political government or political power. It's not matter. Words are not too much important. If you can explain them to me, give some examples in your description. Try not to be too short about your explanations. I hope you will be able to read one page, for example, one whole page of explanation of each elements. And then, of course, we talked about the principal elements, which is the sovereignty. I hope you can define, explain, and give examples of this concept of sovereignty of states. And you can also remind me the fact that a state in international law is a subject of law, it's a legal person, it's a public person, it has legal authority, legal personality. And also maybe you can remind me that there is a distinction between international organizations and states, which is that international organizations have only competencies attributed to them by states. They are also subject of international law, but they have only competencies attributed to them by states. They are governed by the principle of conferral and not by the sovereignty. International organizations are not sovereign, but states are. This is the main difference. States are main subjects of international legal order, and international organizations are secondary, derived legal subjects of international legal order. Which is important for me is the way you explain those things, your ability to explain things, to formulate things, to be expressive, to be rich in your use of terms, etc. Okay, if you do not know everything, it's okay, it's not a problem. Just give me the lecture of your competency, of your talent to make written expression in English about a legal subject which is difficult, which is the international legal order. And as you see the international legal order, it's a mess. It's not too much an order. It's mostly a mess. The international order. This is the international disorder, and so things are going very difficult for legal sphere, legal doctrine, and legal thinking. So it's okay if you, as politists, students of political sciences, it's okay if you cannot explain things as well as legal students. It's okay, it's not a problem. So this will be the examination. Examination will be only 30 minutes. It's very short, so you will you won't have a lot of time to think. So I give you the subject, and I tell you. So why I tell you what I'm expecting from you, application on your expressions and ideas, examples, illustrations. You can also use your general culture. It's okay, but I must be convened. I must be convicted that I must have the conviction that you are okay. You can express yourself in English in a legal thematic. So today I will speak about always about treaties. I couldn't finish my lecture about treaties, international agreements. Those are synonyms, international conventions. And we have already studied that the concept of treaty is not a formalistic concept. That international law is very soft about the definition of the international organization. So, what is an essay for you? What is the difference between an essay and a written? The essay is something with titles, you mean? Can you open your microphone or not?
Hocam sesim geliyor mu?
Evet, geliyor. Buyurun.
Geçen dönem bahar döneminde sadece iki soruda essay yazmıştık. Yani konsept açıklaması vesaire olmadan, short question olmadan sadece essay yazmıştık.
Essay'den neyi anlıyorsunuz, ben anlamadım.
Yani makale deneme yazmıştık. Sadece iki soru essay vardı. Yani short question yoktu açıklamamız gereken.
Ha, short question dediğim yani şey değil, öyle short question.
Konseptler yoktu.
Ne vardı hatırlamıyorum.
Online döneme denk gelmişti hocam.
Ha, şey vardı, evet, çok zordu. Geçen seneki çok zordu, evet. Evet. Yes, last year it was very difficult because we made a homework. It's not.
Evet.
This year it's not homework. It's just a classroom exam, isn't it?
Evet, ödev yapmıştık ve ondan bahar döneminde sadece iki soru vardı. Bilmiyordum.
Bahar döneminde şey vardı, case vardı.
Bir harita var. Evet. Case yazacağız, onu söyleyeceğim.
Yok, hayır, case yok. There will be a question and you will describe the concept of state. It's very easy. Don't look for difficulties when there is not. There's no difficulty, okay?
I need to know something. I speak with Amderlei with two exams in the same time.
Yes,
I'm the student with that problem. Okay. I speak with the secretary and with many people, and I can take the exams in the same time like the others. And I will have a makeup exam.
Yes. Okay.
On 24, I think. They told me it will be on 24. It's Friday, I think.
Same day? It is same day?
No. It's Friday. In the next week, Friday.
Ah, okay. Next week, Friday.
Vendredi.
Vendredi, quel jour?
C'est vendredi.
Quel jour?
Est-ce que c'est le 24?
Le 24 novembre? Ok.
Oui.
Je vais envoyer un sujet pour midterm. Ok.
Merci beaucoup.
Je vous en prie. Okay, let's start. I'm sorry, I'm just noting my. Okay. Yes, another question maybe? No, okay. So this lesson will be about the legal effects of treaties, and I will analyze those effects first of all, I will classify those effects. I will analyze those effects on parties of the treaty. First point of legal effects is the classification of legal effects. And the second point will be about the limitations of those legal effects. And then if I have time, I will make a conclusion about the interpretation of international conventions. So let's start by the first point, the classification of legal effects. Treaties can have effects, effects, legal effects, especially on parties, on contracting parties, contracting states. It can be a state or it can be an international organization. Now you know that a treaty can be concluded also by an international organization. For example, the European Union is participating to the World Trade Organization, WTO. It is a member of a trade organization, so nevertheless, it is not a state, the European Union, it's an international organization. There was a question about the accession of the European Union to the membership of the Council of Europe in order to access to the Convention on European Convention on Human Rights, but it wasn't possible because in 2014 the European Court of Justice rendered a negative opinion about this accession. So it wasn't possible to European Union to be a member of the Convention of the European Human Rights Convention. The first point, so I will analyze the legal effects between parties. The international treaties have binding force between parties, of course. This is the most important principle, the binding force of international treaties between parties. If three conditions are gathered, the treaty will be binding for parties. The first condition we have already studied, it's the legitimacy. The legitimacy, it means that the treaty is concluded between competent authorities. The second condition is lawfulness. Lawfulness, which means that the treaty is concluded by a lawful procedure, which is the first step is the negotiation, and then there is the signature, and then there is ratification or the conclusion. We already saw them, and then publication of the treaty, and the treaty enter into force. The entry of force, which means that the treaty will be binding after the date of entry into force. The third condition, after legitimacy, lawfulness, and the third condition is the reciprocity. The reciprocity, In Turkish, we say it mütekabiliyet in Turkish. And in French, we say réciprocité. The reciprocity means that each contracting parties shall respect the terms of the treaty, shall respect their obligations. The reciprocity means that each party will implement the treaty, will respect the treaty, we will take all measures necessary to realize the application of the treaty, the implementation of the treaty. And this execution of the treaty, this is the execution of the treaty, this execution of the treaty is regulated by the principle of pacta sunt servanda, the principle of the binding force, which in legal terms we say pacta sunt servanda. I'm just putting in the dialogue in the chat. Pacta sunt servanda means that your word make you not slave, but in service of something. You give your promise, you promise something, you have to do it. Pacta sunt servanda, that the word, the promise obliges. And as you can see in the chat column, I gave you the Vienna Convention of 1969, which is a very important legal tool to know, which is relative to the international rules of the conventions of the treaties, international treaties shall shall be applied in respect of this Vienna Convention. But pay attention, and this Vienna Convention is not signed by all states in the world. So the Vienna Convention is binding for several states, but don't forget that this convention is codifying the international custom on the conclusion of the international treaties. As it is codifying an international custom already binding, we can think that terms of the Vienna Convention interests all members of the international community. When you look at that convention, you will see that. Can you see the convention?
No. Yes.
Yes, maybe there is some buffering in internet. Some time there is buffering in internet. So, is it okay now?
Yes.
Okay. As you can see in this convention, the introduction of this convention, as you can see here, the Convention of 1969. This convention is not only a textual international law, it is codifying the customary international law existing and applicable to all members of the international community. So why this treaty, this convention is important? This convention is reminding main principles of the international law about the conclusion and the legal effects and the execution of international conventions. And the rule of pacta sunt servanda is also announced, as well as all other rules, international rules applicable to international conventions. Here, for example, in Article 26, you have the principle of pacta sunt servanda, which means that treaty entered into force are binding upon parties. This is the first principle that I want you to note and to learn, to understand. The second principle is hiding in the principle of pacta sunt servanda. From the pacta sunt servanda principle derives the principle of good faith. The principle of good faith, which in Latin we say bonas fide in Latin language, which is bonas fide. The good faith means that the international convention shall be applied by contracting states in a manner of good cooperation, in a manner of the respect of the respect of the terms and the spirit of the treaty, the respect of terms and the spirit of the treaty. There is another principle which is in the convention, which is formulated in the Vienna Convention, which is the Article 27. It's also important for the international law. And according to this principle of the Article 27, the international treaties have supreme legal value and if there is a conflict between an international convention and a national rule, a domestic law rule, in this conflict between the treaty and the national rule, a contracting state cannot justify the violation of the treaty by the necessities, by requirements of its own domestic law. And it is formulated as that a party may not invoke the provisions of its internal law as justification for its failure to perform a treaty. This is the principle of supremacy of treaties in the international legal order. I would like to make an observation about this principle. This supremacy principle is binding only in international legal order. This supremacy principle has its legal effects only in international legal order. In national legal orders, in domestic laws, those are constitutions, national constitutions, which are determining, which are precising, which are ruling about the legal value of an international convention in the domestic law. So there is a duality. In your mind, you have to distinguish between two legal orders. First, in the one hand, the international legal order, where an international treaty is supreme, has primacy in front of a domestic law. And in the other hand, the domestic legal order, the national legal order, where the treaty has not always supremacy on all other national rules. For example, we know there is a conflict between European Union member states' constitutional jurisdictions and the European Union Court of Justice. This conflict is that in the legal order of the European Union, all EU rules, treaties and secondary law, directives, EU regulations, etc. All EU laws, all EU rules have primacy on every national norm, even on national constitutions. But according to national court of justice, according to national jurisdictions, national constitutional courts, for example, le Conseil constitutionnel français, for example, the Bundesverfassungsgericht, the Constitutional Court in Germany, or the Constitutional Court in Italy, Constitutional Court in Hungary, in Poland, etc., in Czech Republic, etc. For all those constitutional courts of EU states, EU member states, the EU law cannot have primacy on constitutional norms. So when we are talking about international law, my lesson my teaching is about international law. Of course, the supremacy principle of treaties against national rules is only real, binding, admitted without exception on the international legal order, but it is contested, it is rejected in national legal order. So there is a duality, there is a conflict between those two approaches. This is why I took so much time to explain this important issue between systems, legal systems, international systems, and national systems. But in resume, in conclusion, what you have know is that there are principles which ensures the binding force of a treaty between parties. This was the first remark about the classification. The second remark about the classification of legal effects is that international treaties have legal effects exceptionally for third parties. For third parties, which means third party, which means a state which haven't signed, ratified, conclude the treaty. A treaty can have effects against third parties, which are states external to the convention, and which is this effect is an exception in international law. Look at the article of 34 of the Convention Treaty, the Vienna Convention, sorry. Yes, it's the same thing, huh? Convention Treaty or Vienna Convention, those are same things. According to Article 34, a treaty does not create either obligations or rights for a third state, but it is possible in some situations. The first exception is that the third state is giving its consent. The third state is consenting to be binded or to get rights from a convention that it has not signed. This effect, this third state effect of a legal convention is possible for creating obligations or rights for the third state. But rights can be created by no expression, although obligations cannot be created for third states without express dispositions, express announcements of the effect of the convention for the third state. The second exception is not in this convention, but the second exception is about the most favored nation clause. Most favored nation clause. It's very technical exception. I'm not expecting you to know all those things, technical things, but it is, I think, important for a political science student to have this general culture of legal terms which can be used in international relations. And the most favored nation clause is very specific clause that can be found in a treaty between state A and state B. The treaty can announce that the state B will benefit from the same treatment that the state A gave to a state C in another convention. As you can see, the convention between C and A will have an indirect effect on the state B. And that means that state B nationals will benefit from advantages of this convention between state A and state C. For example, Turkey can conclude the MFN clause treaty between Russia in order to give Russian nationals the same advantages given to other nationality, for example, Azerbaijanis or other nationalities. There is a third exception about the legal effect of the treaties on those third states, and this is the case of succession of states. Succession of states, which means that a state can, by revolution, the state can change by a revolution, and so there is no application in this case, but you can notice that if the state has changed, for example, let's take the example of Turkey. If the state changes, like the change between Ottoman Empire and Turkish Republic, so the state has changed. The question is that if Turkish Republic will be responsible for treaties signed by the Ottoman Empire, which is not exactly the same state. There wasn't an unique answer to this problematic. There was two answers possible. In the case of colonies, in the case of ancient colonies of in England or France, for example, mostly there was a tabula rasa solution. Tabula rasa solution, which means that the new state, the ancient colony rejected all conventions signed by colonizing country, by the powerful country between other countries. So it is tabula rasa. So there's no more any convention of the ancient colonizer which is applicable to the new state. The second answer, and this was used by Turkish Republic. The second answer is the succession of the new state to the obligations of the older state according to the express consent of the new state. So the new state can choose between treaties and conventions that it is okay to pursue, and treaties and conventions that it is rejecting. The new state is rejecting some treaties of the ancient state and then accepting some other treaties of the ancient state. For example, the Sevres Treaty between Ottoman Empire and Western powers was rejected by the new Turkish Republic, and the new Turkish Republic imposed to parties of Sevres a new treaty, which, as you know, it is the Lausanne Treaty. Lausanne Treaty that the Turkish Republic required from those ancient powers, Western powers, after the collapse of the Ottoman Empire. But several treaties were maintained. And Turkish Republic admitted several ancient treaties. So it's a choosing possibility for the state, new state, which is theoretically the third state to an ancient convention. So this was the second remark about the legal classification of legal effects. Before the last remark, I would like to make a 10 minutes of stop. Thank you very much.